if I'm not mistaken, they are the only firm that can import coca leaf. They've got special dispensation from the government to import coca leaf to make the Coca-Cola.
Oh, wow.
And some of it's in the trademark. The mental associations people have made with Coca-Cola, and they think about Santa Claus, and they think about polar bears, and they think about Mean Joe Green, and all of these advertising campaigns over the last 100 years. And that's really where most of the value in Coca-Cola as a corporation is in this intellectual property and these intangibles. And so thinking about what you do with copyright, what you do with trademarks, what you do with patents, what you do with trade secrets. I think these are critical questions. If you're planning on a future where you're going to be advising businesses, whether as, external counsel or in-house counsel, if you can't tell a copyright from a patent from a trademark, you're going to be starting on your back foot. And that doesn't mean you have to specialize in those areas, but you've at least got to know what kind of issue you're facing so you know who to go ask.
From the foundational areas like constitutional and corporate law to the emerging areas involving robots, gaming, or cryptocurrency, join us for Season 2 as these faculty members share how they are
taking care of business. Today's guest is the Lula Fuller and Dan Myers Professor of Law, Professor Jake Linford. Jake, welcome to the show.
Thank you for having me.
We're so glad you're here. So perused your resume just a little bit, and I want to just jump right in because one thing jumped out at me. And as we have guests on this show, we're really trying to expose students and listeners to different pathways in life. How'd you get where you are? What do you want to share about law school? And one of the things I noticed is that you have a little gap between undergrad and graduating for law school, correct?
Oh, I have a very circuitous path, right? So I graduated from the University of Utah in 1996.
Okay.
And I started law school in 2005. And between that time, my brother and I had a band. We played music professionally. We were in Wyoming, so of course we played both kinds of music, country and western. And we wrote songs and, toured around county fairs and bars and stuff. We did that for a couple of years. And then I ended up serving a mission for my church. Talk about a record scratch switch. Served a mission for my church actually in Miami, Florida, working with Haitian immigrants, so I learned Haitian Creole. Got home, got married. My wife and I got married in 2000. I spent a couple of years working at my brother's meatpacking plant. I left out the year of radio advertising. I did a year of radio advertising, did a couple of years running the front office in my brother's meatpacking plant, did a year trying to get hired on as a teacher of religion courses to high school students. They didn't hire me. They said have a backup plan, and my backup plan was to take the LSAT. Because I had a buddy who just got into the University of Chicago and was quite enjoying himself. And I thought, well, maybe I could go to law school. So I took some practice LSATs, and they were promising. And so I went and took the LSAT, and I got into the University of Chicago. So I started at the University of Chicago in 2005. I was the older married student.
Gotcha. Most of the people we've had on, I think, law school is their plan A, not their plan B. We don't have many people that say this was plan B, so I find this very interesting, especially your unconventional path of having a band prior to law school.
Yeah, and that led to the type of law I was interested in practicing. I walked into the door thinking that if I got to pick my practice, it would probably be copyright practice.
How so? How does that translate to being in a band?
Well, so when you write songs, the thing, if there's anything that keeps other people from stealing your clever songs, copyright law is supposed to do that work, right? So what copyright law does is it gives you protection over creative works that would include songs, movies, books, etc. For a period of time. Life of the author plus 70 years is the general term. And so I was a little worried they're going to steal my songs, and my brother's father-in-law said, "No, you mail a tape to yourself in an envelope, and that's your proof of ownership." And I said, "That can't be right." I said, "That can't. I don't know what the rule is, but that can't be the rule." And so I started kind of self-teaching myself copyright law. We had to pick a band name, so I started self-teaching myself trademark law. And I said, "Well, there's some interesting stuff here." And so when I got into law school, these were the questions that were the most interesting to me.
This is so funny because the name of our our podcast is Taking Care of Business. Mm-hmm. All right. And one of the first things somebody asked me, are you going to play the music? Taking Care of Business. Can I even sing it? Or going to be
Well, I think if you sing it, I think we're going to be fine.
Well, if I'm not singing it, so let's just go ahead and say that right now. That is not happening.
You play the song over the podcast, and then we might have a licensing issue. That strikes me as possible.
Well, there is someone out there. There's another Taking Care of Business, and he is playing the music. So do you think he secured the rights to that song to play on his podcast? Or is he skirting it, you think?
So generally speaking, that kind of thing is licensed.
Okay.
Generally think, and that is best practices.
Okay.
Right? Now, look, there are detection problems everywhere for copyright owners. So if they don't find him, then it doesn't matter.
Okay.
And then if they find him, maybe it does matter.
It does matter.
And it kind of just depends on who the copyright owner is, and do they think he's got a bunch of money. And different copyright owners are bothered by different sorts of things.
Okay, it's like paying your taxes, Jeff, right? If no one knows you don't pay your taxes, not a big deal until someone finds out, right?
No, it's nothing like that. It's nothing at all like that.
I knew this was going to set him up.
I just want to know. I want to know what the band name was. What was the
This is
copyrighted?
true.
So we had two different bands. The first band, actually, when I joined the band, they had been calling themselves Up the Creek. And then it turns out there was a guy in the next town over that was going by Up the Creek, so we actually had a trademark issue, had to change the name. And so we had an internal debate, and the name we picked was Jackknife, because there's a canyon up home that's the Jackknife Canyon. Only there was a trucking company, and I said, well, why don't we get in trouble with the trucking company? So I made it the Jackknife Band, so it was clear that it was a band. It's the worst name ever, the Jackknife Band.
There's a trucking company
called Jackknife Trucking. Because
that sounds like a horrible name. For a
isn't it, though?
I mean, it's
But
an accident.
That was the canyon he was coming, like he lived up Jackknife Canyon on the Wyoming-Idaho border.
I'm still stuck on the fact there were two bands called Up the Creek.
Where
in the same town, just next to each other. Yeah,
I mean, the next town was like 70 miles up the road because it's Wyoming, right? You know,
it's
long distances here. But still. And then the other band, so we moved to Montana and formed a second band, my brother and I did, or joined a second band. It's like their lead singer... They didn't like their lead singer, and their bass player ended up in jail. And so I was a bass player, and Cal was a singer.
As all bands do have somebody who ends up in jail, right? Isn't that a thing?
There was the splice. And that band we called Cash, C-A-C-H-E, which is kind of a Johnny Cash homage, and, kind of a cool-looking word.
Okay.
And, we had a banner, and, the whole nine.
Do you still play? You play instruments now?
I do a little bit. So actually, when we do the Give Back campaign here on campus, so we do a Give Back campaign on campus, and the students donate to it. And among other things, I think it's a signal to the alumni that the students are invested, and we have really good alumni giving rates, and there's kind of a virtuous cycle here. But I usually incentivize my students with weird things. As everybody else says, I'll donate $5 if you donate $1. I'm like, that's boring. So it's like I'll bring donuts, or I'll dress up in a costume. One year I wore one of those inflatable T-Rex costumes, and I taught class wearing the inflatable T-Rex suit. And this year, every student had a theme song. So here's your copyright problem. I play their theme songs at the start of class, and we've been videoing these on Zoom, so who knows? I'm probably triggering my own copyright liability here. But they all had theme songs, and the panel that donated the most to the Give Back campaign, I played their theme song in class on the ukulele.
Huh? On the ukulele.
And it was Led Zeppelin's Immigrant Song. That was the song. So.
On the ukulele.
On the ukulele.
I love it.
Yeah.
So you teach copyright, obviously. Mm-hmm. You teach trademarks, teach contracts, I believe.
Yeah, I teach first-year contracts class almost every year.
Now, one course I saw you taught, I want you to explain how these go together, was law, technology, race, and gender.
Right. It's a seminar, and the class really thinks about places where law and technology overlap. So a lot of privacy issues, right? So what do we do with police body cameras? And how do we think about all these cameras that people are installing in their homes? And how do we think about, when police keep fingerprint records, or they take DNA, or these firms, these 23andMe firms are running DNA, so privacy issues. How do we think about the way technology, internet connectedness, digital downloads, massive file sharing, massive storage increases have kind of changed the way we think about copyright law, and you overlap that with race and gender issues. So it's pretty well documented that there's kind of disparate impact of policing on minority communities, and some things. So I got a student working on police body camera issues. and some of the racial policing issues there. I've got a couple of students working on papers thinking about access to loans. Now, historically, one of the difficulties with access to loans is white families had access to better neighborhoods, black families were redlined out of certain neighborhoods, and that impacted the kind of value they could build over time. And that ends up getting baked into a lot of the loan issuing algorithms today. And so we're trying to think through issues, what do we do with these algorithms? And are there ways to kind of pull the bias back out of them? And so these are issues, those are race issues. I've got students working on gender issues. So what happens when advertisers are creating unrealistic body image standards using technology like Photoshop? And they've got all these Instagram ads, and it looks like you have poreless skin because they've edited all the pores out of your face. And what kind of things does that teach? These young women who are looking at these Instagram ads and these these TikTok influencers and thinking this is the standard to which I should hold myself. What do you do with revenge porn? Right. So this is a phenomenon where an upset boyfriend, sends a naked picture that he received when he was in an intimate relationship, to the whole world, and what do we do about that sort of phenomenon? And so these are the kinds of questions that we're digging into in the class and kind of thinking about the implications. Now, not every paper students are writing would necessarily be a business law paper per se, but some of them deal with, what kind of financial decisions do businesses make? What kind of decisions do businesses make about the technology that they use, about implications for personal privacy with regard to the technology they adopt. And so that's where I think the overlap is as far as the business law program.
Well, you just answered my next question was, how does this relate to business law? And one of the common themes we have on this show is business law is so broad, but you brought in a whole nother aspect of it today, privacy law, copyright law, things that businesses deal with that maybe we originally didn't consider under business law, but things that obviously our students are very interested in and something that we're going to see more of in the future.
I think, I understand why a classic version of business law was primarily about how do you form a business and how do you deal with bankruptcy and what are your tax issues. But I do think some of the data I've seen suggests that most of the value in most businesses is really in their intellectual property portfolio. Think about Coca-Cola Company, right? So you've got bottling plants, you've got relationships with bottlers throughout the United States, and you've got physical infrastructure. And if they lost all that physical infrastructure, if you imagine the world's weirdest fire that burned every Coca-Cola building simultaneously, I think they would still be able to get a loan to start all over again, and they would ground that loan really in a couple of things. One is the secret formula, right? One is the relationships they've got. They're the only, if I'm not mistaken, they are the only firm that can import coca leaf. They've got special dispensation from the government to import coca leaf to make the Coca-Cola.
Oh, wow.
And some of it's in the trademark, the mental associations people have made with Coca-Cola. And they think about Santa Claus, and they think about polar bears, and they think about Mean Joe Green, and all of these advertising campaigns over the last 100 years. And that's really where most of the value in Coca-Cola as a corporation is in this intellectual property and these intangibles. And so thinking about what you do with copyright, what you do with trademarks, what you do with patents, what you do with trade secrets. I think these are critical questions. If you're planning on a future where you're going to be advising businesses, whether as external counsel or in-house counsel, if you can't tell a copyright from a patent from a trademark, you're going to be starting on your back foot. And that doesn't mean you have to specialize in those areas, but you've at least got to know what kind of issue you're facing so you know who to go ask.
Yep. What do you think, Jeff?
Well, let me ask one quick question that I always had, so I assume some of our listeners do as well. And I know this isn't your area, but it's under the IP umbrella. You brought up patents, and that's not something you do teach. And in general, we hear that is, of course, a very specialized area. And in fact, it seems to sort of, unlike law school in general, where we say there is no major you have to do, is it basically still true that to be a patent attorney, you need to have the kind of technical engineering background?
Yes and no. The yes part is to prosecute a patent, which is the process by which you file for patent protection. You've got to sit for the patent bar, and as part of qualifying for the patent bar, you've either got to have there's a list of degrees, and they're all basically STEM degrees, or, an equivalent in credit hours. And it's, again, STEM style stuff. Now, to be a litigator, you don't have to sit for the patent bar to litigate a patent. You have to be capable of sitting down and having a conversation with your technology specialist and then figuring out how you're going to explain the technology to a jury or a judge in the way they're going to understand. You've got to be able to do that. But it's not necessarily the case that your best patent prosecutors are your best patent litigators.
Right.
I think a lot of people mistakenly assume, kind of building off this assumption that you're asking me about, that all of the IP field, copyright, patent, trade secret, design rights, privacy law, they all require some specialized scientific background. And that's not the case. They do require a certain amount of curiosity, right? And this is, I think, true of every area of the law. You think of yourself as a contract lawyer, but when you really get into your practice, there are going to be certain types of contracts that you're going to specialize in. You think of yourself as a property lawyer. Well, are you dealing with real estate transactions? Are they, sophisticated multi-billion-dollar things? Are you primarily worried about, transferring property from one family member to another, right? Those are both property law issues, and they are really different in the way they shake out. The same thing is true of a copyright lawyer. You might be doing mostly things dealing with music, and music copyright is weirder than most other kinds of copyright, and unless you really want to get into the weeds on that, we won't for today.
We'll have a whole nother music show.
That'll be fine. Just take my word on it. There are weeds there, and they are dangerous, and their monsters lie within.
Well, and I want an Up the Creek intro to that.
Yeah, we're going to have some music intro for
we'll
sure.
We'll see.
Ukulele, please.
Well, we can have that conversation. I'll get you in touch with my lawyers about the licensing fee. But the point is, oftentimes you have a specialization in the type of industry you serve as a copyright lawyer. I remember when I was in practice, I worked for a year in Chicago with this firm called Pattisall McAuliffe, which is a trademark boutique, effectively, right? There were 30 lawyers, and they were all basically doing trademark law. And I was really interested in the positioning of the website. They didn't say trademark lawyer, which is how I would have positioned myself. It's like, I work in my clients are in the auto industry, or I know about beverages, or I know about appliances, or whatever the business is. And that was something that potential clients were interested in seeing, that you have a specialization in this industry and that you know how the industry works.
Well, and I just want to clear up some confusion. I was talking about the other Up the Creek band.
So, that guy?
Yeah.
I never even met that guy.
I wasn't talking about your.
He didn't send
I want the real Up the Creek. The original Up the Creek.
We're going to have to go to Spotify, see if there's an Up the Creek
there.
on there.
Probably is.
Did they make it big time?
I don't think so. Not that I know of.
And did they have a logo, and did they copyright it? Did they trademark it?
See, the artwork you could copyright, the logo to serve as a designator of source, you'd want trademark protection, which you get when you use it, but you could also register it and you get more. Again, there's weeds here. I can go.
There's a semester class here.
Yeah, that's exactly right.
Well, let me pivot a little bit, Jake,
okay.
And let me ask you a more general topic that we've been asking our faculty. And we've been saying one of the things that is sort of unique and special about Florida State is the emphasis on both the teaching and the scholarship, right? That we have this very strong open door policy, that we constantly get ranked very highly on availability of faculty, friendliness of faculty, but we also have a very active, scholarly, intellectually rigorous faculty. And I wanted to get your thoughts on, why is that a positive? Why is it a positive that the faculty is engaging in scholarship? You have this sense sometimes of their writing that takes away from their teaching, when it's really the opposite. But I wanted to get your sense of that as well.
Oh, well, I think that's exactly right. You summarized it nicely. I mean, here's a couple things, right? In some areas, things don't change much. Most of the basics of property law, most of the basics of contract law, most of the basics of tort law are pretty static, and they change slowly. In the areas where I teach, and this is probably true of tax law as well, but in the areas where I teach, there's kind of a continual updating in copyright, trademark, patent law as we have new technologies, as courts are trying to figure out how our existing regimes apply to these technologies. These are statutes that are often getting updates and refreshers from Congress. Whether well thought out or not is another question to have, but things are moving, and they're moving quickly. And if you're not engaged in kind of understanding how the changes are happening. Sometimes these changes are motivated by scholarly inquiry. I've had colleagues testify before Congress both at this school and at other schools, IP colleagues that are really kind of setting the agenda in a lot of ways. I've got colleagues at other schools that are, they wear a litigation hat. They've got their own firms they work with in addition to their scholarship, and all of those things feed back into each other, where I think really in the IP space anyway, copyright, patent, trademark law, the scholarship is driving many conversations for what the shape of the law is and why. And when you can bring that into the classroom, what you get when you understand how intellectual property regimes work is you get more than just understanding what the law looks like in 2022. It's great to understand what the law looks like in 2022, but when you understand why the law looks like that in 2022, what that makes you able to do when you get out of law school is better predict and better adapt as the law changes in the future. And that connection between the scholarly inquiry and understanding the state of the law and taking teaching seriously, I think those all fold together in ways that are very helpful and productive for the student to get a good experience in the classroom and to get one that is broader and richer than what you're going to get in a bar prep course, which is just that they've got to teach you how to memorize a couple of rules of contracts so you can write a 30-minute essay really fast.
And what I've been really pleased at, and I'm sure you've seen it as well, is that that emphasis has really trickled down to the students, that they see the value in this as well. And I am sure you will listen to our first season, but when you do, you'll see that one of our students, Jake, praised you to the sun, had an article published in an entertainment and tech journal. I think it was one of the Texas ones.
Texas IP, I think Texas IP Law Journal is what
and
they call
she
it.
said it was your encouragement that pushed her to do that, and she basically said it was his work and his encouragement that made me realize this is something I want to do and really get behind. And so that was great to hear from the students, because I think they see it is a value. It's not just something that's taking away from time with them.
Yeah, you're probably talking about Ala Tayeb, I imagine. And she is fantastic, first of all. She was really interested in privacy law, so she was in my privacy class, and she was working on a student paper, and her first option for where she wanted to publish it didn't shake out for her, but she'd worked on this paper really hard. And I said, look, I think there may be space for this in an IP specialty journal. And I knew this because I'd had another student a couple of years earlier write a paper for a seminar that I had said, she walked in the door with her first draft of this paper and it was ready to go out the door. She wrote a great paper. And I said to that student, I think we can find a home for this. And Texas's IP Journal took that paper and they took this paper. I think I just need to send a box of donuts to the Texas IP Law Journal every year and say, look, you're going to hear from some of my students and you've had good experiences in the past. Watch for them in the next couple of years. But I think that's right. And I think as the students dig into a subject matter with some depth. And that's the reason we ask students to write papers, write one academic style paper before they graduate from law school, is because that gives them a chance to kind of really dig into a subject, to understand it well, to understand not only what the state of the law is, but why the state of the law is what it is. And as they get that understanding, I think it will serve them better in practice than a number of other things we can do with them. Some other things we could teach them. And frankly, there's nothing like writing and rewriting and editing your own writing to learn how to edit your own writing. And so much of legal practice really is communicating and writing and learning how to do so clearly and succinctly and under significant time pressure sometimes.
You used the word earlier, curiosity, and I think you're really capturing that. You want your students to be curious, it sounds like, and to uncover that curiosity. What can you find out? So in your experience, and as I look at your CV, which is super impressive, so many articles and so many publishings, can you think of one where you discovered something contradictory to what you thought, or something that really stands in your mind as, you know what, I thought I was headed down this road, and after I wrote this article, that is not where I landed?
So I'm working on a current project right now that is exactly this paper. In trademark law, a famous mark, Microsoft would be a prototypical famous mark. Everybody knows what it is, and they really think of it only in that one way. When you hear Microsoft, you don't really think of anything else other than the software seller, right? So when a mark is famous, they get protection in addition to what everybody gets, which is protection against confusing uses. You get protection against a couple of what are called diluting uses, and one of that is tarnishing use. And a tarnishing use is a use that connects your trademark to something problematic, usually sex or drugs. That's been the most successful tarnishment lawsuits. I did a paper, actually, the way this paper developed is I had a student do a study, and she had gotten the paper to a certain point, was graduating, and was kind of done developing this paper. And she had talked to Professor Severe, who's our scholarly expert on evidence law and psychology, and so most of his papers have this empirical survey research point, and he had helped her get that part developed, and I'd helped her with the trademark law. And I thought there was some further developing of this idea, and I said to her, would you mind if Professor Severe and I kind of picked up this paper and carried it across the line? So the first study was basically you take some stimuli, some of them sex-related and some of them drug-related. So there's I won't describe it, but kind of a raunchy imitation of the McDonald's logo, and then a raunchy imitation of the Titleist logo, and then apparently drug sellers have decided the best way to sell sugary edibles is to imitate some trademark like Sour Patch Kids or Reese's Peanut Butter Cups or what have you. And so we did a survey where the test group was exposed to the sex or drug-related prompt, and then the thought I had was there'll be a tarnishing effect and we'll see it, and the respondents will downrate the original brand when they've been exposed to the tarnishing brand. And I thought the effect would be stronger among conservatives than liberals based on an earlier study that I'd seen. And when we ran it, we did see an effect, conservative versus liberal effect. But what we saw is liberals really uprated. There was a burnishing effect, not a tarnishing effect, when they were exposed to the sex or drug-related stimulus. And then conservatives are kind of all over the map. In some cases it was a burnishment, in some cases it was a tarnishment, and some statistically significant, some not. And we did a follow-on study, which was a multi-impression study. This art collective called Mischief had bought a bunch of Chick-fil-A sandwiches and then sold them on Sunday. And their whole ad campaign was, these are your satanic Chick-fil-A sandwiches because they're on Sunday. And so we did a mocked-up news story where we told the respondents, you're reading these news stories and you have to tell us something about the news story. And there were banner ads all around. And one of the banner ads was this Chick-fil-A, you get your Satan sandwich for $6.66 on Sunday, right?
Oh, my gosh.
And we were curious whether there'd be a tarnishment effect there. And then we did a drug Skittles. Mondelez, which owns Wrigley, which owns Skittles, just sued over a bunch of these stoner Skittles, marijuana-infused Skittles. And what we found there is another burnishing effect on wholesomeness for the drug-related Skittles, but a tarnishment effect on tastiness for the satanic Chick-fil-A sandwiches among people who have high religiosity or who are conservative. And so what that tells me is the effect is mixed. It's not nearly as strong as courts have been assuming, and not nearly as strong as I had assumed, because I assumed there would be a tarnishment effect, and I don't see as strong a tarnishment effect. And so this leads to a question as to whether this very big stick that we put in the hands of famous mark owners is really justified or not. And so we've got some thoughts on that, in part because some scholars have begun to suggest that perhaps there's a constitutional challenge waiting in the wings for tarnishing marks. And some of that question will boil down to, did Congress have a good enough reason for extending this protection to mark owners in the first place?
This is so interesting. I mean, not nearly as interesting as tax. Don't get me wrong, Jeff, but this is fascinating. And I can see where your students would just be enthralled in these things. I mean, a thing, and especially in the age of TikTok, anybody can throw something up, tarnish it, use it in an incorrect manner or a manner it was never intended, and thousands, if not millions of people see it and react to it.
Yeah. And one of the questions we're trying to figure out is, firms bring tarnishment claims, but if the burnishment effect is generalizable. And look, there are 4 studies that we know of. 2 of them that show tarnishment effects, ours that shows a mixed effect, a third one that shows primarily burnishment effect and a little bit of tarnishment among conservatives. So this is a mixed story, right? But imagine, 10 studies down the road we're primarily showing a burnishment effect. If that's right, I think it's hard to imagine that I know more about how people react to a given brand than the firm does. And if the firms are pursuing tarnishment causes of action, one of the questions that's starting to bother me now, and I don't have an answer for yet, but maybe 5 years down the road I will, is why do firms chase tarnishment actions? Is it because Congress is holding out this stick and they're saying, well, here's the stick, I need to go beat somebody, I need to send my lawyers and beat somebody with it?
Right.
Is it because, when your decision maker at the firm sees the drug Skittles or sees, a porn parody of an Avengers movie, they're like, ick, I've got to do something about that? Porn parodies are actually an interesting case because there were a couple of famous cases, one from the late 70s where a pornographer had dressed an actress in Dallas Cowboy cheerleaders uniform. And then the Dallas Cowboys cheerleaders sued, and they won the lawsuit, perhaps unsurprisingly. If you go looking for them, I'm not recommending this. I'm certainly not recommending you do it on your work computer. But if you go looking, you will find porn parodies for all sorts of big-budget movies now. And there are very few lawsuits. The last one I know of, I'm probably missing one, but was a early 2000s lawsuit where it was an anime movie, a porn parody of Star Wars. Lucasfilm sues, and the court says, no, you can't go after these guys because they're a parody, and the parody is making commentary on Star Wars, and that's protected. Now, are firms not suing because they think the Star Wars movie is kind of setting the trend? Are they not suing because of what's called the Streisand effect? And the Streisand effect is this. Barbara Streisand doesn't want people to see the back of her house from the ocean. Somebody takes a picture of the back of her house from the ocean. She files a lawsuit to try to get the picture taken down, and what does everybody want to see? The picture of the back of her house from the ocean. Exactly. Nobody cared what Barbara Streisand's house looked like from the ocean until she sued so they wouldn't look at her house. Mm-hmm. That's the Streisand effect. And maybe firms that aren't bringing lawsuits over these porn parodies are just trying to say, look, there's probably a market for this. We're not going to service this market. And all we do if we sue over it is bring the market to top of mind. And that's not what we want. Right. So we're just going to pretend we don't see it.
Yep.
And I don't know if that's what's going on, but it might. It's my theory on what's going on.
Gotcha. All right. Well, we're going to move into the final phase of our podcast. A couple of quick questions and quick answers, and we'll see what you got.
All right.
Someone came to you and said you cannot teach law, you cannot practice law, you cannot be involved in anything in the law. What other career would you choose?
Two options. One is I might be a professional bass player songwriter, so that's a return to my roots.
Perfect.
And the other is a professional game master for tabletop games like Dungeons and Dragons.
I was going to ask any specific game in there, Jake, and I think you already know.
Yeah, I mean, Dungeons and Dragons is a fun game. There are a number of them. That's the one everybody's going to know, so that's the one I'll share because everybody knows that. Okay.
Are you a classic dungeon? I mean, Dungeons and Dragons goes back, 20. Wasn't there like a game board version at one time?
Well,
are you a purist or are you a more recent?
Story. The current edition is the 5th edition, and the campaigns I'm running are 5th edition campaigns because I think the 5th edition rules are actually pretty good. Classic Dungeons and Dragons, and I'm going to invoke nerd rage. Brace yourself. Is not the world's most easy game to play. The rules weren't written in a particularly clear way. Now, they captured something that really captured the imagination of a lot of people in the late 70s, early 80s. The game system is pretty clunky. I think more recent versions of the game system are actually quite a bit better. Now, I could get in very long arguments over the internet that I do not have time for about that, but that is kind of my take on Dungeons and Dragons.
That'll be season 4.
That's
so we'll
season 4.
We'll go back there. Season 4. Tune back in. Okay. How do you take your coffee?
I don't drink coffee, so I take vanilla Coke or Red Bull.
Vanilla Coke or Red Bull, or ever mix them together?
No, I try not to mix.
Okay.
It's like Ghostbusters. You can't mix the streams.
Okay, don't mix the streams. All right. Favorite location to go on vacation? Relax. Chill out.
If I'm going to relax, I'm going to do it on my own couch. We often go, so my wife and I both grew up in Wyoming, so we go back to visit family every year, get up into the mountains, cooler weather. I like to go to cities and see museums and concerts, and so I have traveled ridiculous distances to catch concerts because there aren't near enough touring acts that I want to hear that come right through Tallahassee. So go to Atlanta and catch a show.
Okay. All right. Favorite movie you could watch over and over and over again?
The Incredibles.
Oh, The Incredibles.
That is the best movie. That's certainly the best superhero movie ever, and maybe the best movie of the 21st century.
Frozone? Is it Frozone in that one?
Frozone's in that one.
Frozone's
yes,
a good one. Yeah, that's a good character. Mm-hmm. And the Elastigirl. Mm-hmm. That's really incredible. Yeah. See, I know mine.
It's a great movie.
Movies. All right. Okay. Last question. Are you a morning person or a night owl?
Morning. I'm up most mornings at 5 in the morning.
But no coffee when you get up.
Well,
Vanilla
that's what the Red Bull's for.
That's what the Red Bull's for.
I just put in an IV and just tap it straight in.
So what do you do at 5 in the morning? Got a routine?
5 in the morning. So this year I've got a kid who's taking an early morning religion class at 6 in the morning. So I get him out of bed because he can't get himself out of bed.
You mean your own biological child
My own
taking a
biological
religion
kid.
class at 6 a.m.?
15 years old.
Fif-
Yeah.
I can't comprehend that.
With no small amount of grousing, but he does it. He's a good kid.
That is good. You must be a really good father.
I don't know about that. You'd have to ask him that. We do our best.
Okay, but without that, you'd still be a morning person.
My first year of law school, when I was trying to get ready to teach contracts, it was a heavy lift, right? I'd never taught it before. It was a huge subject. And I was up at 4 in the morning so I could be at the office because I had scheduled myself. Don Widener, our former dean, had let me do this, right? Scheduled me to teach contracts at 8 in the morning, but that meant I had to be ready to teach contracts at 8 in the morning. So I was up at 4, in the office at 5:30, spent 2 or 3 hours prepping every morning so I could teach it at 8 in the morning.
Jeez.
So that was my first year here.
Well, Jake, it has been a pleasure having you. I've learned so much, and we really look forward to the ukulele.
Okay. Well, we'll have that conversation. I'll have my people get in touch with your people.
Sounds good. Thank you for being on the show.
Jake.
Thanks for having me.
This podcast made possible by a generous donation from Jeff and Aggie Stoops.
Special thanks to FSU College of Law's Professor Sean Barron for creating our theme music.